Okay, we are live. Good morning, everyone. So great to see you here today. And today, as you may have noticed from the entire week, this week, I've been talking a lot about technology, legal protection, and software development, and everything that has to do with technology in your business. So, one of the most frequently asked questions I get from technology founders and entrepreneurs is, how can I protect my software or technology? Can I get a patent? Can I register it? What's the best course of action? Now, computer programs are at the forefront of any business. In fact, when you are not a business offering technology as your core product or service, whether it is software as a service or platform as a service or an application, um, so even when this is not the core of your offering, you do have technology that you are using in your business operations on a day-to-day basis. And the reasons are obvious. Either you want to be able to bring your product or service as close as possible to clients and reach as many as possible, or you simply want to automate and streamline as much of the operational and business processes that you have. All of that requires technology. So in this live session, I want to share with you what are some legal aspects that you need to take into account when using technology in your business and when you are, in fact, developing technology? And what are some legal strategies you can leverage that in terms of getting funding fast and efficient? Hi, for those of you who don't know me yet, I am Avocat Olivia Marcu-Iordanescu, and I partner with high-performing technology companies and their founders to streamline their legal processes so they get funding to grow and scale their business. Now, when you are developing software, a platform, an application, or any computer program, you are facing one or more of the following legal challenges. One of them is that computer programs do not enjoy a stable, harmonized, so to say, international legal status around the world. So, in other words, you are based in one country, for example, Romania, founding your business in your country of residence or maybe outside of your country of residence. For instance, you are creating a company in the USA, and your team of developers is based in a completely different jurisdiction, for example, in India. And you are targeting markets that are completely different from all of the above. So, for instance, you are planning on going to market in the UK, in Canada, and so on. So here you are, you already have on your plate a number of jurisdictions and an international law challenge in protecting your intellectual property rights in the computer program that you are creating and planning to market. Another challenge can be that and this is not atypical, right? So, on the contrary, this has become the norm today. Another challenge that you may have is that you are exchanging a lot of information, not just with your peers, your team of developers inside the company, but also outside with your users. And this challenge is called the internet. And what happens when you are exchanging a lot of information and your technology is being used in this process is that you are basically exposing your technology to infringements of your intellectual property. And some examples can include reverse engineering, decompiling components, or copying or hacking the code, and so on and so forth. And third is the challenge of the jurisdiction. If a user of your platform or service is breaking the law in Estonia, but they are on the internet in the United States, which law applies to them? Or do you have jurisdiction over them as a company that is incorporated in another jurisdiction? These are sort of the challenges that you may come across when wanting and trying to protect your technology, your computer program in your business. So software, computer programs, machine learning, artificial intelligence, they are basically developed in a complex economic, legal, and technological framework. But my intention today is just that, to give you a framework of powerful legal strategies I've used in practice to support my clients. It's not by all means legal advice. It's for informational purposes only. And my mission here is to educate. And I hope you find this useful in terms of how can I best protect my intellectual property, as in what is my best legal strategy in approaching this, always keeping in mind that your end game is to get funding so that you can grow and scale your business. And you're always going to need, specific, professional, qualified legal advice to decide on that best legal strategy for you. And you can always do that by booking a free legal strategy session with me. I'm going to drop the link in the comments after the live session. And also let me know, where are you joining in from? And if you have any questions or comments, don't hesitate to DM or message me in the comments. Great. So here are, first of all, some main intellectual property rights through which you can protect technology. So the software in your business, the platform, the application, whatever it is that you are creating and planning to offer to the public. The first one is copyright. I'm going to be touching today actually on copyright, patent, trademark, and design, and finally trade secrets. So briefly about copyright, although there is a lot to say about this, in those legal systems where software is covered by copyright protection laws, copyright applies to the expression of ideas, not the ideas themselves. This is an important distinction. So for instance, source code is protected under copyright. Just the code itself will be protected, not the ideas which are contained. So copyright applies to program instructions, not to concepts behind those instructions. It does not protect, for instance, the underlying technical aspects of the software itself, but it does give the owner an exclusive right to reproduce or copy, distribute, perform, or execute in public, display, license others to reproduce, distribute, perform, or display. The great thing about copyright is that it's automatic. And what I mean by that is that you don't have to register it anywhere. And you have a copyright, an intellectual property right, that is the copyright over the software that you are creating from the moment of creation. There is nothing you need to do in order to have it protected. You don't need to register it with any office, intellectual property office, or any authority, or so on and so forth. And in principle, copyright is owned by the creator. There are those exceptions where, of course, there is a work for hire. You employ someone to develop software for you, and even though the creator, let's say, is the employee, depending on what is provided in that agreement with the employee, the owner of the copyright will be the company for the benefit of which the software is created. Now, I know I said it's automatic and you don't need to do anything about copyright in order to be protected. However, one thing you do need to do is to make sure that you document everything in relation to the development of the software, the computer program, let's say more generally, and that you enter into agreements with anyone that is working on your software, and that these agreements, these contracts, contain very clear, specific sections and clauses on how ownership and title is, who is the owner of the title of the property in respect to that computer program. Okay, next is patent. Now, you may or may not be able to register a patent for a computer program or components of it. This depends on the legal system. And what I mean by that is it depends on the legal system. In principle, where you are planning to create an economic monopoly and market your computer program as a final product or service to your customers. But also in relation to patent, is worth asking yourself whether or not registering a patent is aligned with your overall business strategy, because in the application process for a patent, you will need to make public disclosures. Trademarks is the third intellectual property right. Trademarks are signs used in trade to identify products or services. So what I mean by that is that in a market where you are planning on offering a service or a product that is similar to other products or services, your trademark is going to differentiate you, not just from your competitors, but also in respect to your users, your end users and your customers, and is going to really create that brand that separates you, distinguishes your software as a service from others in the market. Now, in some countries, you can also get protection. So the main thing about trademarks is that you need to register them in order to benefit from the legal protection of a trademark. And there are intellectual property offices in every country. Or if you wish to go for a regional or more international approach, depending on what your business strategy is, that's also available. And in some countries, it may be that you are not required to register in order to get protection, but it may be that as long as it is used, then you still benefit from the legal protection. However, I always strongly advise my clients to register trademarks. And not only that, when you get funding, your investors in the due diligence process, which we talked about, we looked at, and we're going to keep looking at, they're always going to want to see not only that you own your intellectual property, but where registration is available, that you have done that, and that you own a registered, valid, up-to-date intellectual property right. So registering your trademark is a must if not only if you want to protect your assets, but also in order to get funding. A fourth intellectual property right that is very interesting is, and I just want to actually take a step back and say, what does trademark have to do with software, with computer programs, and how can you protect them under that? So for instance, the application of this is that you are going to brand your software as a service or platform as a service or application as a service or whatever it is that your technology looks like when you are offering it to your customers or clients. And so it will come in the form of a brand. You will have logo. That is something that you want to register as a trademark in order to create that economic monopoly and to distinguish yourself from other products or services in the market. Okay, going forward to design, which we said is the fourth intellectual property. Right, design protection is an important business asset for companies. I believe it's underused, but an interesting European Union Intellectual Property Office research shows that small and medium-sized enterprises which own designs have 70% higher revenue per employee than small and medium-sized enterprises that do not own any intellectual property rights. Now, at EU level, the design is the appearance of the whole or a part of a product resulting from features of, in particular, lines, contours, colors, shape, texture, and or materials of the product itself and or its ornamentation. What does that all mean? This is the definition of design from the design regulation at EU level. So as with trademarks, the technical aspects of software cannot be protected by registered design rights. Yeah, we saw that in case of the trademark. Basically, what you can protect is the name, the brand of the computer program or the final product or service. However, design rights can be used to protect the way something looks. So in this context, they could be used in relation to screen displays and graphics of the computer program. And finally, today I want to talk to you about trade secrets, which are a very important intangible asset. And what they have to do with software or with computer programs or machine learning or whatever is the technology behind your business is that these are the secret sauce, those information and ideas that you yourself have in your team and are developing and working on. And you basically, they are very sensitive commercial information, and you basically don't want to disclose them to anyone. Now, of course, there will be situations because they are your secret sauce. Yeah, they are what makes your product work. And at the end of the day, there may be those situations where you may have to disclose your secret sauce. And to elaborate a little bit on how you made that formula happen, how you made it work, particularly to your investors. And but also it may be that you decide to do a joint research and development with another company, with a business partner, or to create a derivative work from your main computer program rights. So in those type of situations, the only way to protect your trade secrets is by signing non-disclosure, confidentiality and non-disclosure agreements, and by including confidentiality and non-disclosure clauses, very specific, very accurately described in those contracts that you are concluding with your business partners. That's it for today. Keep in mind that always when you are seeking to protect your technology through intellectual property, don't think of it in the long run, in the long term, and the finality should be, of course, for you to be able to get ready and prepare to get funding. But actually, the real motivation behind it is to protect your business, and your assets, and technology is the most important asset in your business today. Thank you, and I will see you soon, namely next week, same time, same place. And yeah, again, make sure to let me know your comments or questions in the comments below this video. And you can always book a free legal strategy session with me to discuss what is the best strategy for you going forward in order to protect your intellectual property. Thank you.